to you, and we can get started.
Good morning, everyone. I'm Nadia Shiva. I'm the Specialist Claims Manager for MedMal, Financial Lines, and Cyber. Thank you all for joining us this morning as we will be discussing an escalation in medical malpractice litigation and the increasing size of damages awards. Joining us this morning, we have our special guests, Wim Cilliers and Aaron Carlson of Clyde & Co. Wim is a partner in Clyde & Co.'s Johannesburg office with extensive experience in insurance law, international arbitration, alternative dispute resolution, general commercial litigation, as well as cross-border commercial litigation. Aaron works on litigious matters which focus primarily on professional indemnity, medical malpractice, public liability, and construction law. Wim and Aaron both, thank you very, very much for joining us this morning. I'm also very, very excited to introduce two members of our STAR claims teams, and that would be Marlon Daniels and Marissa van der Westhuizen, both of whom have extensive experience in medical malpractice claims, and they can definitely vouch and say that they are absolutely passionate about these types of claims. Without further ado, I think it's time for us to actually kick off. And Wim, once again, thank you for joining us. And my first question is actually going to be for you, Wim. You know, there's been a raft of delictual claims for damages based on medical negligence that has been instituted in South African courts over the years. We've seen in the media mass reports of these type of matters being instituted against the public and in the private sector. And an interesting fact for our listeners, you know, South Africa is currently sitting at a population of 60.5 million people. And one can easily say that an increasing population could actually be one contributing factor to an increase in these claims. Now, Wim, you know, we trust you with these matters, and we know that you've worked extensively and closely on these matters. What, in your view, has been, you know, these factors which has contributed to the increase in these types of claims and the escalations of such claims?
Thank you, Nadia. A starting point before I answer, thank you for the opportunity to participate. We always see it as a privilege and not as work or any effort to participate in these sessions. And we joked earlier this morning about the 22/02/2022 day, and we spent the morning with I2. So it's great to be with you. To answer your question, patients are nowadays definitely more informed of their basic human rights, and they're more aware of their right to actually institute claims. The question I think that you must ask yourself is, why has there been such an increase? It seems to us that medical negligence claims are no longer your typically amputated the wrong arm type of claim. Patients are definitely nowadays more aware of their rights and the level of treatment that they are actually entitled to. And I think this can be attributed to the campaigns by the HPCSA, for example, to ensure that patients are aware of their rights. And then also you definitely nowadays see a widespread advertising by attorneys in the med-mal space that you haven't seen before. 3 decades ago, it was unheard of to institute action against your doctor. Doctors were, with respect, and I say it with respect, they were above the law and untouchable. You wouldn't sue your doctor even if you knew that he was wrong. And it's obviously because it is a very noble profession. And from there, you do have the traditional perception that they are, in a way, untouchable. I think in the late 1990s, I actually tried, I don't have a positive recollection when I started with my articles, that you had CP claims. And there's definitely, from that perspective, there's a new perception. I think another reality that we must keep in mind, and I also say it with respect, it's specifically in the public healthcare sector as well. We have a problem with poor standards of healthcare in certain sectors, and it obviously creates a perfect storm potentially, and it's a good ingredient for litigation if you sit with poor standards of healthcare as well. And then lastly, I think another very important trend is there's, in the attorney's profession, from a personal injury point of view, definitely a movement by attorneys away from your traditional road accident fund work, because attorneys don't want to deal with the road accident fund anymore. So what do you sit with? You sit with attorneys with personal injury expertise. So what they do, they refocusing and they focus on medical malpractice claim where they can use their personal injury law expertise. But what we do see also from time to time in our practice is the mere fact that you can do a personal injury from a road accident fund perspective or road accident claim perspective, it doesn't mean that you can advise clients on medical malpractice claims, because medical malpractice claims can become very, very complex. But there is the idea that I can just refocus and do medical malpractice work. Some attorneys do it very successfully, but it's definitely a driver, people moving away from road accident fund claims.
Thank you for that, Wim. My next question is going to be for Aaron. Aaron, I'm going to put you now in the hot spot. In 1991, a South African doctor, Dr. Strauss, in his publication, Patient in the Law and Practical Issues, discussed the incidence of medical malpractice litigation in South Africa, comparing it to the trend in the United States of America. Although we recognize that medical malpractice incidence was on the rise, he, for special reasons, was positive that we could never ever reach the pandemic proportions of those in the United States. Now, what is your response to this statement? And also, take us through the numbers to actually give us an indication of where we sit and which specializations have we seen the highest spikes in claims.
Thank you, Nadia, and just thank you again from my side for having us here today. Nadia, we've definitely seen an increase in claims. Having regard to stats, if we have a look at, there was an article in the Business Day in 2019 looking at the 2018 financial year, and particularly with regards to matters instituted against the state for medical malpractice claims. We see the state sitting at a contingent liability of over 80 billion rand. Now, as you can see, there's quite a big jump from the 2015 financial year where we're sitting with 28 billion rand in contingent liabilities. So there is obviously a clear increase in claims. One of the things that the Actuarial Society of South Africa, in fact, did when we started realizing this trend was they started investigating the reasons and the possibilities for why medical malpractice claims are increasing, but by looking specifically at the figures. This report actually helps us quite a lot to have a look at a little bit more recent figures, and particularly within the public sphere. I'm sure you are aware of Gregory Whittaker. We actually use him quite often as an expert in our matters as an actuary. And he authored this report, and it was published in April last year, where they start looking at the figures and where they discuss a few reasons for the magnitude of the increase. And what's quite shocking is in our 2020 financial year, we see an increase in contingent liabilities in the provincial departments of up to 115 billion rand. Now, this is obviously a major concern, and specifically for us in South Africa, in an industry, or in a country, sorry, where resources are very scarce. But what we do need to know is that these are our contingent liabilities. So it's not necessarily the amount that is going to be paid out at the end of the day. Government is looking at these figures as what the plaintiff is actually claiming. So what is the claim amount in the particulars of claim? This is obviously before we've even seen if the matter itself actually has merit, and before we've done any quantum investigations. So, for example, one of the things that Whittaker actually raises in the report is there's a matter that where a plaintiff is claiming 50 million rand for general damages after having to deliver a stillborn baby, and due to negligence, her uterus had to be removed. Now, we don't necessarily have similar case law in South Africa of the unlawful removal of a uterus, but Whittaker has a look at cases in Swaziland, and there was a similar matter in 2019 where the plaintiff was only awarded 450,000 rand. So that just shows you that while we are sitting with a contingent liability of 115 billion, that's before the matters have been fully investigated, and particularly before we've done any quantum investigations. Just with regards to your, sorry, before I go there, what Whittaker also did was he had a look at actual numbers. So comparing the actual total claims paid in the various provinces over the 2018 and 2019 financial years. And while we can see that some of the provinces there has been an increase in claims being paid, others there's actually been a decrease. So we look at the Western Cape, for example, which is the last line above the total at the bottom, where in 2018 we had claims of over 80 million being actually paid out, and in 2019 we had only 60. So it does show that while there is some increase, we've also seen a little bit of a decrease in claims being paid out throughout the provinces. That's with regards particularly to the public sector. Private sector stats are obviously a little bit more difficult to come by, but we were able to find an article from the Medical Protection Society in 2017 where they dealt with just the stats of these increasing claims. And the MPS showed that over the years from 2011 to 2016, they had seen a rise of 35% in the number of claims being instituted against your healthcare professionals, and particularly with regards to large claims amount being increased. So 121% of claims being over R1 million. What we also noticed, and maybe going in line with what Wim mentioned earlier about the awareness campaign from the HPCSA, they've also seen an increase of about 100% in complaints actually being lodged at the HPCSA over the last 10 years. So it is quite clear that there is an increase in medical malpractice claims. Just to answer your last question with regards to what particular matters we've seen, in our experience, for example, we've seen quite a bit of an increase with CP claims, so your cerebral palsy matters. And one of the reasons why we think that this is so is because South Africa itself actually has an abnormally high prevalence of cerebral palsy among children. So again, if we just look at figures, compared to the global figures, South Africa is sitting at 10 cases per 1,000 births, whereas in the global market, it's only 2.1. So when we start considering that in 2018 alone, there was 1 million births, having a look at these stats at 10 to 1,000, it's no wonder that there's an escalation in these types of claims.
Okay. Thank you for that, Erin. It's actually reassuring to hear that less claims are being paid out, especially in the state sector, because then there's a lot more budget to actually be allocated for something else. So my next question is actually going to be for Wim right now. Last year there was an opinion piece published in the Wits Clinical Journal. It was titled "Healthcare in Private Private healthcare in South Africa. Expensive doesn't always mean excellent." The author, following the death of her husband in the publication, took the view that currently there's almost nothing that a relative can do to ensure accountability for a loved one's demise. The author also took the view that civil litigation is complex and expensive and frequently not possible in the case of death. The HPCSA is extremely slow and variable, and there's absolutely nothing. Private practitioners are not held accountable to anyone. But what is your view of those statements that has been made? Because from our side, we do see claims where, loved ones of a deceased actually prosecute these further.
You're on mute.
Sorry, Nadia. I agree with you. Accountability is definitely an issue. From a lack of accountability point of view, we actually sit in South Africa, I think, with the ingredients for a perfect storm. Firstly, doctors in private practice, they're not employees, but they're independent contractors. And therefore, they do not have to answer to an employee or to an employer, like in many other jurisdictions across the world. Then you also have an unpredictable, as you have mentioned, HPCSA as the only governing body who can hold doctors accountable. The other potential ingredient is the fact that there's almost no system of peer review in private practice, in the private healthcare system, to monitor the conduct of doctors. Then private healthcare facilities also do not make outcome statistics available like in your public healthcare. So you can't monitor it, you can't follow trends. Then obviously the court system is also a problem. The court systems are slow and the court systems are inefficient, and it does have an impact on your access to justice. Then another potential ingredient is, or let me just rephrase, first say, private hospitals do normally have admission privileges, and they also have the right to terminate those admission privileges. But you seldom in practice see that admission privileges of doctors are actually terminated, because it's obvious, it's a drastic remedy. I think in an ideal world, the legal system in any country and in our country is supposed to be the moral compass in order to hold doctors and medical practitioners accountable, which is just fair. I do believe, I think a good attorney can hold doctors liable for financial losses, and you see it every day, despite all the inefficiencies. But from an accountability point of view, if you look beyond financial losses, from an accountability point of view, there's a lot of scope for improvement, no doubt about it.
Okay, thank you for that. I'm now going to hand over to Marissa. Marissa, you next.
Okay, so Erin, let's talk a little bit about the increase. So we've seen a clear increase in the number of medical malpractice claims, as well as the size, or what we would call the quantum of these claims. Let's discuss a few aspects around the increase in the size of claims, or the quantum of claims. We know that certain aspects of a claim is more susceptible to concrete quantifications like past medical expenses, past loss of income, and the like. There are, however, certain aspects that are more abstract in nature and therefore more open to debate or negotiation, which is sometimes good news and oftentimes bad news for us. Can you speak to us a little bit about the rationale behind general damages, the more abstract kind of damages, and what has our court's approach been with regards to general damages?
Yes, thank you, Marissa. So our general damages are non-patrimonial damages. So exactly like you mentioned, you know, there's a little bit more susceptible to judgment calls, and it's often a little bit more difficult to get a concrete quantification going. So what our courts have done in the past is they've specifically looked at case precedents. Now, we're dealing in general damages with things like pain and suffering and emotional shock or emotional distress. So you're never going to get one case that is exactly the same. Somebody may feel more emotionally distressed after a specific trauma than anybody else, or somebody may take a little bit longer to recover from an operation than another person. So you're never going to find a matter that is exactly the same. But of course, in order to get some kind of precedent and something that we as the attorneys can rely on to guide us in future general damages cases, we do need to look at past case law. What we've specifically noticed, Marissa, in our matters is that general damages, or plaintiffs, are claiming slightly higher amounts in general damages, but particularly with regards to emotional shock and trauma. So we thought it would be nice to just chat about that today and focus specifically on matters with emotional shock. So just to have a an idea of matters that we've dealt with in the past. We settled the matter in 2020. It was a cerebral palsy claim where the plaintiffs claimed R1 million. The plaintiffs being the mother and the father of the child who was diagnosed with cerebral palsy, and claimed R1 million for emotional shock and trauma. Now, that is quite a high amount, and we'll get into the specifics on how we deal with these types of cases. But having a look at the expert evidence and having a look at previous case law, we settled that matter on 300,000. So again, it just shows the difference between what is being claimed and what we actually value the claim at the end of the day. In another matter last year that we settled, in a pharmaceutical claim, the plaintiff claimed 500,000 Rand, also specifically for emotional shock and trauma, after she was dispensed the wrong medication and it caused a miscarriage. Again, looking at previous cases, taking expert evidence into account, we settled the matter on 150,000. Now, when I say taking expert evidence into account, one of the things that our courts have specifically mentioned with regards to emotional shock and trauma cases is that the plaintiff has to prove a recognizable psychiatric illness. And it was specifically mentioned in the Kumape matter, and we'll in fact deal with Kumape a little bit later on in the discussion. But it was specifically mentioned in there that anxiety and depression are normal human emotions. And in terms of the common law, no damages was awarded for emotional stress because it's a normal emotion to, be depressed or be anxious after a traumatic event. So what our courts have said is, in order for a plaintiff to actually claim for emotional shock, we need to prove that there's a recognizable psychiatric illness. So plaintiffs are going to have to employ expert evidence, psychiatrists, clinical psychiatrists, psychologists, to be able to show that it's more than just grief or bereavement, following, for example, the loss of a loved one, or following the trauma of an operation that's gone wrong. They're going to have to actually show that they are suffering a detectable or recognizable illness. Once they can show that, then for us to be able to consider appropriate awards, again, we have to look at the circumstances of every case. They are going to all be different. People are going to react differently to different traumatic situations. So once they can prove that there is, for example, PTSD, post-traumatic stress syndrome, or anxiety disorder, depression disorder, something to that effect, then obviously we also look at the circumstances of the plaintiff. Is it temporary? Is it permanent? How much distress has this person gone through? And then we can consider what an appropriate award would be. And exactly like you said, it is a judgment call. At the end of the day, we don't have concrete findings like past medical expenses that we would be able to quantify these kinds of damages on.
Thank you. I think it is reassuring for everybody to know that there is at least some sort of a framework employed by our courts to ensure that the damages awarded is essentially fair to both the plaintiff and the defendant. Do you have a couple of other examples that you can share with the audience in terms of awards made for general damages in other matters?
Yes, definitely. And, exactly like you said, it helps not only the plaintiff and the defendants, and it helps the attorneys as well, so that we don't have a situation where we're sitting with a plaintiff's attorney who's claiming an exorbitant amount and being awarded such an exorbitant amount. And then we just have this downslide of plaintiffs now claiming these kinds of amounts. Our courts are going to look at expert evidence. They're going to look at the circumstances. And we're going to look at the past cases. So if we have a look, for example, we can see that emotional shock and trauma, awards will range anywhere between 100,000 and about 400,000 if we look at what the value of the claim would be today. So for example, in our Mbekhlele matter, where the mother had to give birth to a stillborn baby after suffering negligence during her labor, she was awarded 100,000 rand. And one of the factors that the court specifically considered was that after giving birth to the stillborn baby, she was taken back to the maternity ward where she had to see and contest with mothers who have just given birth, who just have their newborn babies. And she had to see that while knowing that her baby was born dead. So that was something that the court took into consideration and awarded 100,000 rand there. In another CP claim against the MEC for Health in the Eastern Cape, we have a slightly higher award for a mother who claimed damages for emotional shock after her child was diagnosed with cerebral palsy. And again, in this matter, the court specifically had a look at our expert evidence, specifically had a look at the type of psychiatric illness that she's suffering from, and also considered the long-term effects in light of the fact that she would have to be dealing with a child with permanent disabilities for the remainder of the child's life. So in 2018, they then gave an award for 300,000. In Kluter versus Minister of Safety and Security, I've included it here on the slide, just actually more of an example of when courts will take into account when you don't have enough evidence. So it's not a South African matter, it's actually a Namibian case. But in this matter, the plaintiff was unlawfully arrested and she was assaulted by the police. And while the court accepted her version and believed everything that she had said, unfortunately, when it came to the emotional shock side of things and the award that she should be given there, the court specifically said that there was a lack of opinion evidence with regards to being able to prove the extent of the emotional distress. So there they actually only awarded 50,000 Namibian dollars. In our Kamape matter, I'm sure you've heard of this matter. It made big news at the time, where a little boy died after he fell in a pit at the toilets in a rural school. And the parents instituted a claim against the Minister of Basic Education, where they claimed for their damages, and where in fact they also claimed constitutional damages. But with regards to emotional shock, this is quite a good judgment to show the difference between how the awards would be dealt with and how a court deals with each person differently. So, just because you're a family doesn't necessarily mean you're going to all get the exact same award. Parents received 350,000, whereas, for example, the younger children who may not be feeling the effects of the trauma as significantly as the parents, they have only received 100,000.
Thanks for that, Erin. I think what makes these things difficult is the fact that we're dealing with an imperfect form of compensation. We're trying to provide money as a sort of a compensation for a loss that cannot rightfully be compensated for in terms of money. So oftentimes people would look at these numbers and say, I had to give birth to a stillborn baby and be exposed to, other mothers, being so happy about the birth of their healthy children. And you think 100,000 rand is not sufficient, but we must remember that, money cannot essentially make good the loss that these people have suffered. And yeah, it's oftentimes something that we need to keep in mind to limit the liability, but also just to keep the human aspect in mind and not to lose our humanity in dealing with these matters. Then I just want to speak, and this Kamape discussion is a nice little link to the next topic and the final question from my side. And this is in keeping with the more abstract aspects of claims for medical negligence. And over the last couple of years, we have seen a seemingly novel entrant into the claim space, where a large portion of claims intimated by way of summons contain a specific claim for what they call constitutional damages. And this is often in addition to the already abstract general damages, and it seems to be based on an infringement of various constitutional rights, like the right to life or human dignity, or similar rights. Plaintiffs or plaintiffs' attorneys, which we know they are interesting people to deal with, often claim an additional amount of, let's say, 500,000 or R1 million as constitutional damages. And Erin, as you mentioned, on that unlawful removal of the uterus, you know, the 50, I think you mentioned 50 million. So these claims would generally range in varying degrees of absurdity in terms of the quantum. But should we be, so this is essentially my question, should we be concerned with this seemingly new component to medical negligence claims?
Marissa, to answer that question first, before dealing with it in detail, while it is certainly something that is coming up in our law, and it's certainly something that we need to consider, I think our law and our SCA, and particularly the Constitutional Court, has dealt with it quite appropriately, having regard to damages that plaintiffs will receive in terms of a delictual claim, and versus damages that they would receive if they were to be awarded constitutional damages. And I think a nice starting point with that is also just a quote from our Komape judgment, where they specifically say that depending on the facts and the circumstances of any particular case, the approach of awarding constitutional damages to mark displeasure may be justifiable in theory, but there are practical considerations as well. So, for example, in Komape, where the plaintiffs claimed and they were awarded emotional shock and trauma, they claimed on top of that constitutional damages against the Minister of Basic Education, where they said that their rights to a peaceful family life had been breached. And they also tried to make out the argument that the award for constitutional damages would actually force the authorities, and in particular the education department, to provide adequate sanitation in all schools. So the SCA considered it, and in fact referred to a matter in 1997, where it was FOS versus the Minister of Safety and Security. The plaintiff in that matter was assaulted and tortured by a policeman. And he again claimed for his usual delictual damages, and on top of it for constitutional damages. And in dealing with this question, the Constitutional Court in FOS actually specifically mentioned that granting constitutional damages on top of delictual damages would not be appropriate, especially in circumstances where you're trying to use constitutional damages as a deterrent for the government to force them to ensure basic rights are properly maintained and that kind of thing. To be able to do that and to be able to make a significant mark, the award also needs to be substantial. So in considering whether that would be appropriate in the circumstances, the court in fact said, and specifically in a country where resources are scarce, to award a plaintiff additional damages in addition to his delictual claim would actually be inappropriate. And the better use of the funds would be to actually use the funds, to, for example, supply adequate sanitation, as opposed to now going to a plaintiff who's already been awarded damages. So our Komape judgment considered this matter, enforced it once again, and specifically also mentioned that the public purse would be far better utilized for the benefit of many, rather than paying a handful of people a substantial amount of money over and above what they already have. So just to go back to your question, while it is certainly something that, as the SCA said, is great in theory, I think in practical terms, when you have a plaintiff who's already been awarded damages, we're not going to often see a court be quick to award constitutional damages.
Thanks for that. I think that is all from my side. I'm going to hand over to my colleague Marlon to discuss a few possible solutions.
Morning, and these questions are for Wim. Morning, Wim.
Hi, Marlon.
The Law Reform Committee has suggested a few proposals to deal with the increased volumes of claims and quantum. Amongst them is improving the quality of public health care. Wim, would you be able to talk us through the other suggestions, please, for the benefit of our audience?
Yes, perfect, Marlon. It's a very valid question. The South African Law Reform Commission recently published proposed solutions to deal with the medical malpractice claims, specifically in the public sector. And the solutions are currently open for input. And we assisted a private hospital group in formulating input. They published the suggestions in November last year, 2021. And input from the public and the private healthcare sector is due by end of February. And the primary purpose of the proposed solutions is to address the crisis in the public healthcare sector, but implementation will obviously have an impact on the whole industry, including the private healthcare sector. And the main question that the Commission is dealing with is, can be summarized as follows. It is, what alternative solution could be offered that is affordable, point one, and then point two, achievable in the South Africa of today. The constitutional right of access to courts can never be denied, but taking the matter to court should, as far as possible, be avoided if it's possible. An unreasonable limitation, such as a limitation of compensation and limitation to access to courts, will be open to constitutional attack. In terms of the constitutional test, the limitation must not be unreasonable. So that's going to be the tricky question. What the Commission proposes is a uniquely South African system, and it's a sort of a hybrid of specific international examples, and then an expansion of the development of our common law that has already been initiated by the Constitutional Court. But then, very important, as I've already mentioned to you, it must be without any unreasonable limitation of rights. They've got three focus areas. Firstly is primary prevention. Primary prevention is to prevent an incident from happening. Point two is secondary prevention. That is early detection if an incident does happen. And then the third focus area is a tertiary prevention, and it is to reduce complications and then also consequences. The Commission identified 8 broad suggestions. The one that you've already mentioned, it's to improve the quality of healthcare, specifically public healthcare, where the main problem is. Then the second broad suggestion that they're dealing with is record keeping. In order to create a culture of better record keeping and to educate the sector on better record keeping. And the question is why? Well, the answer is obvious. Record keeping is critical in mounting a defense in medical legal matters. The failure to take proper records, to keep and to maintain those records, and to store those records, appears to be one of the main issues causing the state in establishing a defense. They have, in the audit field, they've got a saying, auditors, they always say, if it's not in writing, it's not done. And it's the same culture that you must also have in the medical malpractice industry. If it's not in writing, it's not done. We see now in our own practice often that the lack of proper record keeping often creates an unnecessary hurdle in a matter that could actually be defended if you had proper records. So that's the second suggestion. The third suggestion is just to emphasize again the importance of incident reports. Incidents are inevitable. It's going to happen. But the culture must be created to encourage the public health care sector and then obviously also the private health care sector to have proper incident report systems in place in order to report those incidents. The fourth suggestion, and that's perhaps a bit more controversial suggestion, that's the issue of limitation of compensation. The Commission proposes structured settlements in the form of structured payments, and then also changing underlying principles for calculation of future loss of income, and then capping of certain categories of damages. We have our own views on it. I think any capping of claims and the structured payment will, in respect of the private healthcare system, unreasonably limit a patient's rights to claim. But it's my own view. It may, however, in the public sector serve a purpose because there you must consider measures like affordability, and then also you must prevent the collapse of the public healthcare system. I think in respect of future loss of income, it can work. The proposal that future loss of income be premised on structured format of guidelines based on the average national income of an area, for example, in which a claimant resides. But this should take into account the general context-specific information considered by our industrial psychologists when they quantify claims, such as immediate family education and qualification history. But I think specifically on the future loss of income and the structured format of guidelines to be used, there's a lot of refinement to be done before you will have a successful system that will survive the constitutional attack. Regarding the proposal for capping of constitutional and general damages, I think it can work, but we must always keep in mind the fact that the claimant has been disadvantaged as a result of a wrongful act or omission, and that therefore any capping of these claims should not be to the claimant's detriment, but rather as a deterrent from awarding punitive damages and the inflation of claims by attorneys, as we see every day. So, to summarize, limitations on compensation, it is workable, but it's no doubt you're going to see a constitutional attack. Then the fifth suggestion by the Commission is more collaboration between the public and the private sector, and the Commission then also deal in detail with recommendations on mediation as a suggestion, and then also a system of what they refer to as a certificate of merit, a proposal that a plaintiff serve a certificate of merit affidavit by a medical practitioner before plaintiff can actually institute formal legal action. And then lastly, the Commission also deal with on the procedural side with recommendations on changes to our civil procedure.
Thank you very much, Wim. My next question is, given the lengthy waiting periods to obtain trial dates, is mediation a more cost-effective alternative dispute resolution to resolve the issues? And in addition, the SA Medical Association has called for the establishment of specialized medical courts to deal with medical legal cases. And Chairperson Dr. Angelique Coetzee said, magistrates are often placed in the unenviable position of adjudicating exceedingly complex clinical interventions without possessing the necessary training or medical expertise. This has severe and long-ranging impacts on doctors and ultimately on patients. Something must be done and quickly to remedy the situation. In your view, would the establishment of these courts be a viable solution, and what would these entail? Furthermore, how can litigation processes in general be amended to deal more efficiently with medical malpractice claims?
Marlon, I'm first going to deal with the issue of mediation. The Commission proposes that mediation should be voluntary, but that it should be compulsory to make a bona fide attempt at mediation before instituting court proceedings. I think the idea of mediation to avoid litigation is obviously, on principle level, a very good idea. However, I am skeptical that it will in reality and in practice be successfully implemented, specifically from a public sector point of view. The state is in general unwilling and incapable of mandating its representatives to enter into settlement agreements. We see it every day in the public sector. They would rather run a case than settling it because nobody wants to take responsibility to give an attorney a mandate to actually settle a matter. So I can't see any reason that mediation as dispute resolution mechanism will avoid litigation. If you don't change the mindset, it will only be achievable if there's mechanisms in place in order to force the state or to give attorneys actually mandates to settle matters. I think from a private healthcare perspective, obviously it's definitely achievable because you can get instructions much quicker by picking up a phone, and there's in general a good relationship of trust between attorneys and their clients from that perspective. From a rule perspective, the current civil procedure rules have actually already been changed to make provision for mediation. You must, for example, file a mediation certificate when you enter an appearance to defend. So there is already scope in the rules, and then later in the process as well, as part of your pre-trial processes and your case management processes, the parties must discuss the issue of settlement once all information has been gathered. So the process is there. It's sometimes more about implementation. My own views on mediation, you must distinguish between facilitative mediation and evaluative mediation. Evaluative mediation is where you appoint a mediator to evaluate a matter and to actually give an opinion. Facilitative is where the parties just interact with each other. I think there's scope for evaluative mediation process, but then on the basis that you must be in a position to make medical legal reports available at the earlier stage of the process and not only just before trial, because you need those reports in order to evaluate the merits of a claim. I think then, in principle, the mediation can definitely work. I think if you can force attorneys to make medical legal reports available earlier in the process, for example, by annexing it to your particulars of claim, and then also by annexing medical legal reports to a plea. And I know it's not always possible, but at least to force an attorney to do it earlier in the process. It will also make attorneys think twice before they actually issue summons. Because what we also see plaintiff attorneys on a fishing expedition. They're opportunistic with respect, taking a chance. You issue summons before you properly investigate the matter. So you need a mechanism to force plaintiffs to actually make their reports available as part of the issue of summons process. And from that perspective, I think the certificate of merit idea of the Commission is good. The proposal that you must serve a certificate of merit signed by a medical practitioner when you issue summons. You can actually take it a bit further by annexing all the medical legal reports, because I'm skeptical. I don't think you can just annex a certificate certifying that the prospects of success are reasonable, because we all know these claims are very complex sometimes, and sometimes you must address it on multidisciplinary level. But it's a step in the right direction, certificate of merit approach. Then lastly, on the civil process, your question on specialized courts, I think, or before I deal with that, the one suggestion was also to issue joint expert reports. I don't believe that the issue of joint expert reports will solve the problem, because we're in an adversarial system. We're not in an inquisitorial system like in many other jurisdictions. I would prefer the specialized court scenario. The Law Commission recommendations up to now is they're not optimistic that it's achievable because of cost considerations. I do not necessarily share that reservation for the simple reason you can have a specialized medical legal court as a division of the High Court without additional costs, but by having specialized medical legal judges, existing judges with experience in medical legal matters. It's like your tax court or your patent court. It's a division of the High Court. It's existing judges, but they've got experience in that specific field. So I think the specialized court idea is definitely achievable and a good idea. You can then also combine it with assessors to assist the judge, but then I would only, from a cost point of view, recommend assessors in highly exceptional circumstances, because if you do have a specialized court, you'll have the comfort that you've got a judge experienced in med-mal matters. Then you only need assessors in groundbreaking matters.
Thank you very much, Tom. And my last question to you is there scope between the private and public healthcare sector to provide better care? And has there been positive outcomes from this partnership?
Yes, it's a difficult question. I fully agree there is scope. And the private sector can actually support the public healthcare sector in providing the sector with strategies and protocols for effective hospital management, training of staff, and other systemic issues which the public healthcare system faces. There is, in fact, actually already enabling legislation to promote quality of healthcare. In terms of Section 41 of the National Health Act, an MEC of a province can, for example, appoint members with legal expertise to hospital boards to assist in managing the legal implications of poor standards of care. So there is scope in our current legislation. I want to read something for you, and it's from the, or before I read it, what we also see in practice, several organizations like SAMLA and the Society of Obstetricians and academic institutions, they have hosted conferences, and they do it on a continuous basis, and they do workshops at their own expense to come up with solutions to address the medical legal crisis in South Africa. In 2018, we also saw the President hosted the President Health Summit in October 2018. And I want to read something to conclude from the executive summary of the summit. And they said, what they said is the following. What is exciting is the realization and acceptance by all the participants of the notion that the health system can never be fixed by the health department alone. It requires a focused, practical, and collaborative approach. The government and participating stakeholders continue to demonstrate their commitment to improving the health system to bring new dawn with a desire to see not only a halt in the deterioration of the health system, but a massive improvement in its functioning for the benefit of all South Africans. The stakeholders are committed to work together for the next 5 years to improve the health system. This was said in 2018. Now, what the Law Commission, or what the Commission said in November 2021 is the following in response to this. It says, yet like all the numerous reports, policies, guidelines, declarations, proposals, and other documents that preceded the Presidential Health Summit Compact, it is not clear what tangible outcomes the summit and declaration have eventually achieved. The Commission therefore proposes, before yet another report is commissioned, another ministerial task team, a ministerial advisory committee is appointed, or another summit, conference, or workshop is held, that the work that has been done already be fully implemented. So this is unfortunately the reality, if I can end on a bit of a somber note. There's a lot of ideas and a lot of work has been done, but from an implementation perspective, it's still a long way to go.
Thank you very much for that, Tom. Certainly sheds a lot of light on what is to come.
I saw a few questions. I actually made a few notes of a few interesting questions.
Yes, there's quite a few questions that have actually come through on the chat. And the one question is from Lindy van Straten. Regarding doctors in private practice, I see a lot of them that don't have any med-mal cover whatsoever. What does the law say about this? I know of a few OBGYNs, for example, that does not have the cover in place and haven't for many years.
Nadia, it's not at this point in time compulsory, but the Commission is also considering the issue of insurance cover. But what I do know is that there's definitely a trend from private healthcare, especially your private healthcare facilities, as part of your admission privileges to enforce compulsory cover. And we definitely see it more and more, but it's not compulsory yet, unfortunately. And the other issue is also, you do sometimes find doctors that's actually uninsurable.
That's interesting to know.
And it's very expensive. Some areas like obstetricians, it is, in some respects, actually nowadays, it's not affordable for many doctors.
That's true, eh? That's really true. The next question is from Sharon Bourne. Can a malpractice suit be directed to support staff at a doctor's office?
Can a malpractice suit
be directed to support staff at a doctor's office?
I don't follow the question. Sorry, I just want to find it.
Okay, it's the one right at the bottom in the chat.
Okay, can she just clarify the question, Sharon? Or...
Sharon? If I can maybe jump in while we wait
okay,
for
yes,
clarification.
Take it.
I'm not sure if maybe by support staff you mean the nursing staff, or if you're actually talking about assistants at a doctor's office. Nursing staff, of course, we've seen those cases, and as a nurse you're employed by the hospital. So of course the hospital then gets sued as the employer of the nursing staff. So definitely you can have a malpractice suit against them. But as we say, it then is directed against the hospital itself. And the hospital would then be vicariously liable for the negligence of the nursing staff if negligence is proven.
Thank you, Erin. So the next question is from our own Kamini Shan Magam. What is the effect on contingency fee agreements, the number of on contingency fee agreements, the number of med-mal claims? Would tighter regulations and monitoring of these agreements have an effect on the frequency of litigation?
It's a very good question. Contingency fees are governed by the Contingency Fee Act. What we do see nowadays, obviously it must be signed and in writing, but what we do see in order to regulate the agreements and compliance with the Act, many of our jurisdictions have practice directives in place that if you settle a matter, that you must, as part of the settlement, also hand in your signed contingency fee agreement, and sometimes legal representatives must actually confirm that there is compliance. So there is, from that perspective, a monitoring process. It's not always efficient. In order to answer Kami's question, I think further and tighter regulation will not necessarily, it's my own view, have an impact on the frequency. For the simple reason, attorneys in this country, they are litigation hungry. Then if you look at the broader context that I've explained when we started, you see a movement away from road accident fund claims. You have thousands of attorneys in this country that relies on personal injury work as their bread and butter. So they move away from your road accident fund claims, and I don't think tighter regulation is going to have an impact from that perspective, because they want to do the work.
Okay, thank you, Wim. And one of the second last question that we do have is from Hugo du Plessis. Your views on possible legislation being considered, such as COID and RAF, to limit excessive or inflated med-mal claims?
It's a very good question. And the Commission actually also considered that as a possible solution. And I think the general consensus is that another piece of legislation is not going to be practical, because the moment that you have another piece of legislation, you must set up a statutory body, it becomes an administrative system that you must administer. It's not necessarily, I think there's a realization that it's not going to be the answer to the problem. And I think government has also learned from prior experience with your road accident fund example, that it's not always the solution. I think it's actually good news.
Okay, thank you for that. I think we can take one more question from the group, and I think this question is from Reggie Chetia. The compensation of 100,000 for stillborn baby, what would be the legal costs?
Well, 99% of all plaintiffs' attorneys work on contingencies. So depending on their contingency fee agreement, it will be anything between 15 or 25% of the 100,000. No. And then they can also tax the party and party costs, but the tax costs are supposed to go back to the plaintiff's attorney, to the plaintiff. Unfortunately, in practice, we don't always see it, and it's actually, you must pay it back to the plaintiff. Not entitled to keep it, it's illegal.
Thank you for that, Wim. So this brings us to the end of our iTuesday this week. Thank you, Wim and Erin, for joining us. And to everybody out there, once again, thank you so much for your love and support. And we look forward to seeing you again.
Thank you very much.